Hey everybody, Dustin Schanaker at Fowler St Clair. Wanted to talk to you a little bit about the importance of having powers of attorney documents. Now there's two types of powers of attorney. There's healthcare powers of attorney, and then there's durable general powers of attorney. And these documents are important because if something happens to you or a family member that makes it so that you cannot make legal decisions for yourself, these documents allow an agent to act on your behalf. And it happens without having to go through court. And so the normal circumstances where somebody's maybe in an accident and they're in the hospital and either in a coma or they're not able to make the medical decisions for themselves or even financial decisions. The other alternative is for other people that maybe have been diagnosed with dementia or Alzheimer's, and they aren't able to now make or sign legal documents. And so having a power of attorney in place allows those decisions to be made by your agent. And so with healthcare power of attorney, your agent can make those healthcare decisions for you on your behalf while you aren't able to do it for yourself. And then the durable general power of attorney deals more with financial decisions. So maybe you need to refinance a house in order to pay for healthcare, and you don't have the capacity to do that. And so your agent can now sign those documents on your behalf. Or maybe they need to go open a bank account or something like that where it requires the legal capacity to make decisions which you don't have, but your agent can do that on your behalf. The alternative to having a power of attorney document is to go through the court process of having a guardian or conservator appointed on your behalf. And so the problem with that is it takes quite a bit of time, about 6 to 8 months. It also costs quite a bit. If you hire an attorney to do that, you're going to be spending several $1,000s to be appointed as that guardian or conservator for your family member. And so the important thing is to have that document in place now because it avoids having to go through the court to do ultimately the same thing, which is have somebody there that can make those decisions on your behalf. For example, I had one client whose wife had been diagnosed with dementia, and they needed to refinance the house in order to provide for her ongoing healthcare needs. But the problem was the dementia made it so that she did not have the legal capacity to sign those documents. And so they did not have a power of attorney in place, which meant the only alternative was to go through court and have the husband appointed as guardian and conservator for her. And so as we were going through that process, he continually said, "Why did nobody tell me about this? Why didn't I know that I needed a power of attorney?" And I said, "Well, I didn't know you at the time or I would have told you. The problem is you don't know that you need one until it's too late to get one. When you know you need one is when you have some type of thing preventing you from signing legal documents, and by that point you now don't have the capacity to sign a power of attorney document." And so here's your PSA then is powers of attorney are important documents, and you need to get one now before it's too late and you don't have that legal capacity to do so.